Well, welcome back, Lord Frost, to this hybrid European Affairs Committee here in the House of Lords, and welcome for the first time to Susanna Simon, who's a director in the Cabinet Office with responsibilities for the trade portion of the Trade and Cooperation Agreement. And thank you both very much. I know how busy you both are for coming along this afternoon. This is a public session, and so a transcript will be taken, and we'll send it to you in due course, and we'll be grateful of you advising us of any corrections that need to be done. We only have an hour this afternoon, and
why is that? Why have we only got an hour?
Unfortunately, Lord Frost's diary is very busy, and he has a very important call on the Northern Ireland Protocol later on.
That's a pity, isn't it?
It is a fact of his diary, and we'll obviously have to take it up out of this session. I would therefore ask that all questions and answers are kept short, so that we can get through as much of what is a fairly long question set as possible. And to that end, perhaps I could begin. In May, Lord Frost, when you were last here, you said that we were in for quite a bumpy ride for some months. And I wondered how bumpy you thought the ride is at the moment.
Well, first of all, thank you, Chair, and thank you for having me. And it's very nice to be here in person with everybody again. Looking forward to the discussion. I think you're right. We said it would be bumpy back in May. It still is a little bit bumpy in various areas. I do think it's important to kind of contextualise this, though, because the bumpiness attracts the attention, and there's a lot going on that is not quite so bumpy. I like to think, first of all, that our relations with most, if not absolutely every member state are pretty good. We've got a stream of inward visits, many prime ministerial contacts. We've just signed, for example, on Monday, a partnership agreement with Greece. We signed something similar with Germany earlier this year. Others are underway. So that sort of bilateral side of the relationship is working well. Equally, I'd say most of the TCA is working well. As I've said before, customs arrangements, the practical relationship with member states' customs authorities is going well. Issues such as visas under the new services arrangements of the treaty, we have good practical discussions with member states. Some of the very small wrinkles in the law enforcement arrangements are being ironed out. And so I think it's important when we look at the areas of conflict, so, fisheries, I guess at the moment where we are on Horizon and Northern Ireland, it's important to see it in that context. We've got an agreement or two agreements of huge breadth covering virtually every area of our sort of international life, and in most areas that's working extremely well, considering how suddenly it came into force and how much there is to do. So although the bumpiness attracts the attention, I don't think it's really correct to say the entire relationship is bumpy. Bits of it are, and they're causing turbulence, but there's a lot else going on as well.
Thank you very much. We'll come to a number of the areas that you've mentioned in that response. When Michael Gove was last here in February, he talked of, and I'm looking at what he actually said, that there came a moment where the crew tell you to take off your seatbelts and to enjoy a gin and tonic with some peanuts. And I wondered when you thought the gin and tonic and peanut moment would actually finally come.
I think it comes when we have found the right equilibrium on the Northern Ireland Protocol, and as I was saying in my speech in Lisbon, I think that is the key to putting things on a better footing. The mistrust that's being generated by the protocol is getting in the way of lots of other things. However, if we can put that on a better footing, I really have no doubt that we'll be in a better place quite quickly, and we can get the drinks out.
Very good. A final question from me, and that is that one of the bumps is a bilateral bump that has been going, or a multiple set with France, and for instance the AUKUS agreement there. And I wondered whether you felt that this bilateral spat was something which was getting in the way of the UK-EU relationship, and how you intended to deal with that.
Well, France is obviously a major player within the EU has a lot of influence over the Commission, and that obviously colours a few things. I would say not everything, not even most things, but it does colour areas of dispute. I suspect. I think as regards France, I think we have ups and downs in the relationship, and we've had very significant downs in the past, in the run-up to the Iraq War in 2003, when I was in the embassy in Paris, and we're able to move on from these things because we have not only so much in common, but so many common interests where we're forced to collaborate, work together, make things work between us. And so, without sort of downplaying the difficulties we've got at the moment, nevertheless, it is a positive, important relationship that we would wish to put onto a better footing if we could. Obviously in a way that works for our national interests as well as France's, but it is not something we're casual about, and we would like to get things back to an even keel.
Thank you very much indeed. We move to Lord Jay.
Thank you, Lord Chairman. I just want to ask a question about Northern Ireland, Lord Frost, if I may. The government's response to the Commission's proposal, the recent Commission's proposals on the protocol published in October, sounded quite positive. But there's sort of a moment of turbulence seems to have crept in more recently, and I just wondered whether you thought there was a chance of reaching agreement in the negotiations which are going on at the moment.
So, I hope there is. We're working on the basis that there is. I think, some things were important in the Commission proposals. They don't go, I think, far enough to solve the problems we've got at the moment. But two things are important in them. First of all, they accept that the problem is not solved by simple implementation of the protocol. That was the Commission's position at the start of the year. It no longer is the case. Both sides agree there is a problem that needs to be resolved by something changing in the current arrangements, and that's what putting these proposals on the table reflects. And I think, secondly, they have accepted that it is possible to change EU internal rules and laws in order to deal with the situation that is presenting itself in Northern Ireland. And again, I think that's a very important Rubicon to have crossed. Now, they haven't, I don't think, got far enough up the opposite bank yet of the Rubicon, but I think an important moment has been passed. So that's why I'm kind of realistic about these talks. There is a big gap, obviously, between the command paper and what the Commission has put on the table, but I do believe that it's the right thing to try everything to see if we can work these proposals into something closer to where we wish to go. And, of course, it takes two to reach an agreement. That's obvious.
Leaving aside the European Court of Justice, which I could come up in a moment, I mean, is it your view that on other grounds, on the sort of trading issues, progress really is being made, and the prospect of an agreement there and the negotiations now going on is possible? I mean, is that the area where you feel most confident, if I can use such a powerful and positive word?
I think there remains a gap. It's true. But I think we're not in positions that are diametrically opposed to each other on this, as we are in other aspects. I think, if I summarise, extremely and simplify massively, I think our approach is that goods moving into Northern Ireland should be subject to essentially no processes and checks, but there are exceptions to that, most obviously goods that move on into Ireland. The Commission's approach is the reverse, which is that everything is subject to processes, but things can be carved out of those processes. Now, obviously, you could get to the same point from those two very different starting points if the wish existed to do that, and perhaps we can, but I think the reality is there's still quite a gap, because I think what the Commission have put on the table doesn't get that close to allowing a lot of trade to flow freely into Northern Ireland, and that's what we're trying to achieve here.
And just one final point. I mean, I've been involved in European negotiations for 30 years or so, and in many of them there comes a time when both sides sort of agree, okay, well, it's been going on long enough now, there's a sort of terminus ad quem, we're going to reach an agreement by Christmas or whenever. Do you have that sort of view in mind, or is there no terminus ad quem to these negotiations?
I think there is a terminus. It just isn't one that necessarily ends in agreement. That's the difficulty. I think both we and the Commission would like to move this on and ideally resolve it this autumn, so there isn't a lot of time left. That's why we're trying to work as intensively as possible at the moment. Obviously, it's no secret if we can't reach agreement and we still face with a significant political problem in Northern Ireland, then Article 16 exists. It's in the treaty, and that would be one way of dealing with it. But I hope we don't have to go there. It's much better to do it by consensus. So that is obviously one possible way out of the process this autumn, if we can't do it any other way.
Thank you, Lord Chairman.
Thank you very much. Lord Lamont.
Following on from that immediate exchange, if Article 16 is triggered, what would you anticipate would be the range of options which would be available to you? And do you envisage that any of the policies you might pursue would require legislation?
So I wouldn't wish to go into too much detail about what could and couldn't be done under Article 16, because obviously it is part of the kind of negotiating positions. I think I will begin by saying Article 16 is a safeguard. It isn't a sort of, protocol self-destruct clause. There are reasonable limits on what you could do under Article 16, and we accept that we are working within those limits. Having said that, Article 16 is a pretty unusual provision and potentially quite sweeping, and those limits could be quite large. So that's the space that we're working within, and if we do take measures, they are safeguards. They have to be targeted on the problems that have arisen and the way the protocol is working that is generating some of the current difficulties. So that's how we would see it. I think on the domestic legislation question, simplifying massively, obviously there is a provision in the 2021 Withdrawal Act that gives direct effect to a European Communities Act-like provision that gives direct effect to the protocol. It therefore also gives direct effect to Article 16, because that's part of the protocol. But I think you might probably would still want some secondary legislation, so there's kind of no doubt about the intention of the Article 16 action, and to make sure that the UK legal order was kind of completely clear and we knew where things stood. So that's my sort of expectation at this point.
Well, what is your view on what people call the Swiss-style arbitration panel to deal with the conflict in the position of the ECJ and the position as we think it ought to be? And do I understand that by a Swiss-style solution, what people mean is separating an arbitration panel which would adjudicate on wider points, but it would leave the ECJ at the same time still interpreting what EU law was?
So I think that is what people mean by a Swiss-style arrangement, though I don't think it's actually a particularly accurate description of the Swiss arrangements, which obviously are quite, go back quite a long way, are quite complicated, and don't, with the exception of aviation, don't really have an explicit role for the court in quite that way. But that seems to be what people are talking about. I think where we are is, I go back to the command paper. It gets simplified by talking about the court, but the court is simply at the apex of a system which imposes EU law in Northern Ireland without consent, and we tried to be clear about that in the command paper in the relevant paragraph. It's about the whole thing. We don't think it's right or likely to contribute to stability for the Court of Justice to be resolving disputes between the two sides. We can't do anything about the fact that the EU makes this very expansive claim for the interpretive powers of the court, and indeed we had to kind of acknowledge that in a way in the TCA, sort of by carving it out of the way that it worked. So we can't do anything about that reality. But then it raises the question of, okay, so where does EU law apply? And therefore it takes us back to the beginning of that argument, which is that the problem is far too much EU law applies directly in Northern Ireland. That's the core of the problem. We don't see that so much of it should apply, and therefore the interpretative role of the CJEU is also limited.
So you would reduce the areas to which EU law applied directly if you had your way?
So I think in yes, and we said in the command paper in paragraph 71, we talked about in any areas where EU law, for example, where EU law is applied or replicated in Northern Ireland. And obviously one way of dealing with this problem is replication. It's not the only way of dealing with it. But the problem we have, and this is why we keep focusing on long-run stability, is that if you maintain a system where lots of EU law applies without consent, in the end you set up divergence between Northern Ireland and Great Britain as we legislate in a different way, and therefore it's not a stable system. Therefore you've got to have some other way than the simple application of EU law into Northern Ireland, because that's the generator of the problem. So that's why I think the court thinks of simplification. One has to look at the total system. How do you deal with the total system that allows these privileged trading arrangements for Northern Ireland into the single market, yet makes that reconcilable with democracy and kind of normal dispute settlement arrangements? That's not a simple problem, but it is one we would like to have a proper conversation with the EU about, but we haven't quite.
Might have time to come back to that later on, but in the meantime, thank you for that. And Lord Little.
David, you've always been very clear that you think that there's not much point to Brexit unless we diverge. I don't agree with that, but it's a perfectly legitimate point of view. And you've set up this commission to look at opportunities for divergence and all the rest. When the government's thinking about this, presumably they're going to take into account the possibilities of EU retaliatory measures as provided for in the TCA. And the person who is best placed, as it were, in government to advise on that question is you. So would you be advising the Commission about the potential for EU retaliation on any proposals for divergence? How does the government propose to make this work and assess the risks?
So, it's a very good question. One of the reasons why I've got my particular mix of portfolios is because they sort of come together in the way that you describe. And it is my job to try and sort of work this through. I would say actually we are kind of already beginning the discussion that you describe between us and the EU. The first specialised committee on the level playing field has already met, and indeed we have had a sort of I guess you would say fairly preliminary exchange about some of the things that are in the offing on either side. So it's very much understood that significant divergence in a way that distorts trade, to use the language of the TCA, can produce countermeasures. I mean, I think any side contemplating that has to look at is there a genuine distortion of trade? Is the process followed? Is it worth it? And I, as I've said before, believe that in many ways kind of healthy competition between systems is a good thing, and watching what the other side does, as it were, and maybe learning and imitating from that is a good thing. So I don't think it's not axiomatic. The only possible response is retaliation or trade defence measures. Another possible response is to watch and learn and improve what we do collectively.
Yes. But if I could just come back on that, I mean, are you, if you take a view that there is a significant risk of retaliatory measures, would you then recommend to the government that it didn't go ahead, or would it depend on what you thought the benefits of divergence would be?
I think it depends on the context.
Yes,
obviously,
indeed.
it depends on the subject matter. It depends on what's at stake and the economic size of the interest that you're talking about. I think our approach would be to be fairly bullish about the benefits of divergence, and that was likely to produce kind of spin-off benefits for both sides. But we don't kind of ignore the risk. The risk is there. But we have to be focused on our own ability to grow, our ability to improve our own productivity and so on, and that comes from domestic reforms that we make, and we must be focused on that, even if it comes with a risk of retaliation. I tend to sort of downplay it personally.
I'm sorry, could I just ask a point rising from Lord Frost's? You mentioned your reference in the Lisbon speech to healthy competition between regulatory systems. Do you not recognise that Mrs. Thatcher signed the Single European Act in order to get rid of the unhealthy competition between regulatory systems?
If I'm honest, I think that's probably an oversimplification of what the Single European Act does. I wouldn't claim to know what was in Baroness Thatcher's mind at the time, and I know that you were obviously more closely involved at the time, but I don't think I would say that the purpose of the Single European Act was to create an entirely homogeneous single market in which there was no competition between systems in any way. I think as we have it now, the single market is a mix of legislation set at European level with a degree of discretion, and some areas that fall out of EU competence altogether, and the Services Directive, as it finally emerged, is a good example of that. So I think it is more complicated than you suggest, if I'm honest.
Thank you very much. We're a little bit behind time.
I'll speak more shortly.
Perhaps we could move to our first virtual committee colleague in Lord Trenchard.
Thank you, Lord Chairman. I hope you can hear me. I had some IT difficulties, but I hope I've got over them. Minister, at the Partnership Council in June, it was noted by both parties how critical the governance structures and the implementation of them is to the agreement. And I wonder how they are working. I mean, you had said that you expected most of the specialised committees to have had an initial meeting before the summer. What is actually the situation? And is their working being adversely affected by the present bumpy ride in UK-EU relations?
It's all going a little bit more slowly than we thought before the break, I think, but nevertheless on a good forward track, I would say. There are 18 specialised committees, 14 of them have now met, and the remaining 3, which I think are on aviation safety, road transport and administrative cooperation, have dates have been set for 3 of them, and the remaining 1 on union programmes, i.e. Horizon, doesn't have a date set, and that's one of the problems. Susanna has been more closely involved in these committees sort of day to day than I have, but I think it's fair to say they've gone pretty constructively. The agendas have been quite wide-ranging, and we are getting the system working, I think, is the short version. And I would say there's been pretty minimal kind of contamination effect from the wider problems in the relationship to these.
Well, that's very good. Could you say a little bit more about the last one, the Horizon Committee? I wondered whether cooperation as envisaged under the Horizon programme is being hampered by the current state of our relationship.
So there seems to be a problem. We're not quite sure what it is, because obviously back at the end of last year, the EU had not passed all the necessary legislation to make the new programmes work. So the relevant bits of the agreement were sort of draft agreements, but there's a commitment in Article 710 of the TCA that the EU shall implement our membership of Horizon and the other programmes. So the EU has now passed all this legislation, and yet we still haven't completed the process, and we're not sure entirely why that's the case. One could speculate, but it's never actually been said to us. And we wouldn't want to get into a situation where one side was not delivering on its treaty obligation. I note that the Commission spokesman today said that they fully intended to make us members. Well, do it then, I think, is all I can say, and we can start getting it working properly.
Thank you very much.
Thank you very much indeed. We move to Lord Tugendhat.
Lord Frost, I come to the question of import controls. 3 times now, businesses have undergone the time-consuming and expensive business of gearing up for import controls, and then the can's being kicked down the road. Do you feel that a moment will come where this asymmetry becomes unsustainable, and what steps do you feel need to be taken to reassure business that either something will be done or it won't be done, if you follow me?
I do, and I think there are a number of factors that weigh on the decisions we've taken over import controls over the last year, and although we would have liked to provide total certainty about the dates, in fact the last year and a half in the economy has been so unusual in all kinds of ways that we have not wanted to kind of add to the burdens, and therefore thought that the right thing was to move these back. I think we will stick to the dates that are now in place unless we get another terrible wave of the pandemic, but I think barring that we're confident. I don't entirely buy the argument that says because the EU do it, we must do it. I mean, there's obviously some merit in leverage if one's trying to achieve things. At the same time, just because they impose a burden on themselves doesn't mean that we have to do the same. And I would be surprised if we, when we finally bring in these controls in January and July, do exactly the same thing as the EU does. I don't think we would see their levels of checks on SPS goods and live animals as entirely proportionate, for example, and might not do the same thing ourselves.
I think that's a very interesting reply, if I may say so, and I think a lot of people would do well to study that reply. It leads me, if I may, to an additional question. Could you envisage a situation in which we do not impose import controls, and over time the EU takes the view that you have just enunciated, that perhaps they aren't required? Could you imagine us not imposing them and in due course the EU lifting them?
So I think, we will impose them. I think it's simply a question of kind of what goes with, what level of controls and process has to go with them. I think our aspiration is to have the best border in the world by 2025, and I think that the best border in the world by 2025, we've set that out, and our aspiration is to have a well-managed, light-touch border that applies to all third countries by that point, EU and non-EU alike. And if we can do it well, I would expect the EU might look at that. Its customs code does date from quite a long time back now, and frankly a sort of slightly different world. And I would expect them to want to improve it if it could be seen to be done differently.
Thank you.
Thank you very much indeed. We move to Baroness Jolly.
Thank you very much, Lord Chair. Lord Frost, the government opted to delay the introduction of many SPS requirements until July next year, but it's retained the previous deadline for the introduction of full customs controls, and they're still due on the 1st of January. So could you tell us what was the rationale for delaying some checks and controls but not others?
So it essentially depended on, to a large extent, what we felt the burden on business of the next step was, and sort of how far down the road we already were. So as regards customs controls, there is sort of myth that we're not doing customs controls. We are doing customs controls. What we're not doing is absolutely every aspect of them at this point. And what we're doing at the end of December, if you like, is filling in the gaps, removing the ability to do deferred declarations, which most aren't using already. So we felt the extra burden of just kind of being clear, normal customs controls were in place, was not going to be significantly onerous compared to where we were now. SPS controls are different. You need veterinary certificates. You need a whole different set of process, and we felt businesses just needed a bit longer to get ready for that. So that's the logic.
Okay, thank you very much.
Lord Faulkner.
Could I take you back, Minister, to preparations for the revised deadlines, which where July is now the time we're looking at? Can I ask you what steps are being taken to ensure that government and business will be ready for those this time round? And can you guarantee that the timetable won't need to be delayed again?
So you would expect me to say this, but we were confident that as regards government preparations, we were ready on the original timetable that was deferred. But of course, that's sort of the easy bit. The important bit is whether economic actors are ready to do it on the same time, and that's obviously more complicated. Now, as I said, we felt they'd had enough to cope with this year already, and that's why we moved it out to give us a bit more time. So there's a very active sort of programme underway of talking to trade associations, talking to the big traders directly, the high value traders, both here and in the EU, to try and make sure people know what the requirements are going to be, and that they are ready for them. And we can't guarantee we'll be able to get it to everybody, obviously, but we're trying our best to make sure that people are prepared. And so far the signs are good that, given how long we've still got, this should be okay.
Thank you. And can you just clarify what you meant in your speech in Lisbon about the need for border controls and checks maybe not required to the same level of risk? We don't believe the level of risk requires them. What did you mean by that, and what specific areas might the UK have lower levels of checks and controls than the EU?
So, one area is the area I mentioned, which is SPS and agri-food goods, where, without in any way compromising the high standards, the EU has its law requires extremely high levels of real-life checks of those goods, which it doesn't often reduce. And, we might well, I'm not saying that this decision is taken, but we might well come to a view that is disproportionate compared to the actual risk, at least from some countries. So that's one area. Another area might be customs paperwork, where at the moment we've inherited the EU's sort of single administrative document because we've inherited their laws, but it's not obvious you need to collect every single piece of information that's on that document and process it in that way. So those are the sort of areas I think we'd like to look at, not rushing at it, because everyone needs time to adapt and there would need to be time to change rules, but over the next couple of years to see if we can improve the process.
And how do you envisage the EU will react to that, if that's the route you go down?
So I mean, I hope they would look at their own processes and think, maybe we could improve. They could improve their own. I mean, in an ideal world, and we'd still be open to this, of course, we would do this kind of together and mutually agree that certain things weren't needed or could be done in different ways as part of a trade facilitation agreement. And we tried to kick that off in the negotiations last year, and it never quite took. But if they are still open to that, we would do it. But otherwise, I think it's sort of imitation and learning. That's the best way. When we do our best-in-class border, we'll learn from how it's done elsewhere in the world.
Thank you very much. We move to the second of our virtual colleagues in Baroness Cootie.
Thank you very much, Lord Chair. Good afternoon, Lord Frost. I'd like to move now to UK exports to the EU. At the first meeting of the Partnership Council in June, we raised with the EU the need for greater consistency in the application of customs and SBS controls to our exports. And indeed, last week we took evidence where we were hearing about the inconsistencies across various different countries in the EU apply these controls. I'd like to have a little bit more detail from your perspective of where you see the issues are. Is this still an area of concerns? And have there been any developments recently in this area?
So I think the first thing to say is, generally it works well, and so far, I think the general approach that's been taken by European customs authorities, who are still national, even if they're working to EU legislation, has been to be quite sort of pragmatic about things and not insist on everything being done perfectly, but to allow trade to keep flowing. There are cases, as you say, that we're aware of where goods have got stuck. And usually we're able to unstick them, and our embassies in particular are very good at kind of identifying these sorts of problems. But I would say they are, if not isolated, at least they're certainly not characteristic of the overall relationships. I think some countries are somewhat more problematic than others. I don't particularly want to sort of go into public, but there are one or two that crop up from time to time. But I believe that just general continuing to work the channels and get people used to the way this works is going to deal with most of these problems. We have put in place, very last thing, the Export Support Service, which is in a sort of soft launch, as you would say, which I hope will get a bit harder quite soon, which is the DIT's new support arrangements for companies to help them deal with some of these sort of process questions. So that is open and easily found on gov.uk, and we are encouraging people to use this if they need to.
We were hearing last week about certain countries that are being perhaps a little bit more draconian, shall we say, about some of the checks which they are imposing, more so than they are with other third countries that they're trading with. Do we have a specific process in place to deal with those countries and these issues? Or, I just want to understand, how are we capturing the data of where the issues are, and how are we then processing it very specifically bilaterally with countries where certain checks are being difficult? Yeah,
so there are two processes to deal with it. One is the relevant specialised committee, because ultimately the rules that operate are subject to the TCA, and if UK companies are not being treated as they should be under the TCA, that is a problem for the EU, and that needs to come up in the specialised committee. Obviously, we can't do that for every single problem, and we've managed it in different ways with different countries. For example, with Portugal, which I happen to know just because I was there, as is known, a couple of weeks ago, we've set up a sort of contact point process within the Portuguese administration. They've set one up which aims at sort of resolving these questions quickly as they arise, rather than having to hunt down the right person. So those are the sort of mechanisms that we're using. It hugely depends on the volume of trade and the nature of it with the different countries. But that's to give a snapshot of some of the ways we're trying to deal with this.
I think part of the difficulty seems to be the interpretation of the CCA, where some countries are perhaps being much more literal and strict about the interpretation, as opposed to being more pragmatic. And that may suit their domestic agenda to do so, and indeed their domestic economic and trade policy. And I can see that might be much more difficult to resolve than when actually the interpretation is actually incorrect.
Yeah, I think... actually, to be fair, I think I don't think many, if any, countries are doing this as a matter of policy, except perhaps in one or two areas. I think it's more the way the rules get interpreted by particular bits of the customs system. Some bits and some people are more assiduous in this than others. I think that's more of the problem than a deliberate attempt to cause us problems, because I'm just not seeing huge amounts of deliberate attempt to do that, and there hasn't really been at any point this year.
Thank you very much indeed.
Thank you very much.
We move to Lord Hannay.
Yes, data. In your statement to the House on the 16th of September, you said, I quote, "We intend to create a pro-growth, trusted data rights regime more proportionate and less burdensome than the EU's GDPR." In diverging from, which that is implicit in that statement, in diverging from the GDPR, is there not a risk? Is there a risk that the government will jeopardise the adequacy decision for the UK, which was taken by the Commission in June? And has the government carried out a risk analysis of the potential cost to the UK if that were to happen and the adequacy were to be withdrawn? And would the terms of the TCA, in fact, in those circumstances, permit or perhaps even require us to consult with the EU before we started to diverge?
So I think where we are, all those things are possibilities, definitely, as we evolve the rules. But we are at a very early stage. As you say, we have data adequacy at the moment. We have announced a consultation, launched a consultation on how to do things differently. We're in the middle of that consultation at the moment, and I think it closes later on this year, and obviously that will be the basis for any reforms, any legislation we decide to put in place. And excuse me, I'm sure we will talk to the EU about that. There are processes in the treaty that allow that when we get to that point. And in so doing, I'm sure we'll want to say that we are putting in place a regime that provides for very high standards, but in a somewhat different way, and maybe in a more light touch way, but provides for the same standards. And obviously the EU has given adequacy to other countries that don't operate the GDPR, because it recognises they're providing similar levels of protection. I don't see why we shouldn't be in that position ourselves. That would certainly be our aspiration, because we've no wish to reduce standards. We want to do things better.
Thank you.
Thank you very much. The third of our virtual colleagues is Lord Wood of Anfield.
Thank you, and thank you, Lord Frost. I want to ask you about cooperation with the EU on criminal justice and law enforcement. So in February, the government repeatedly told the Security and Justice Subcommittee that it was confident that it would pass the evaluation tests set out in the Trade and Cooperation Agreement, assessing Britain's suitability, the UK's suitability to share sensitive data under the so-called Prüm arrangements. And this evaluation test was supposed to take place within 9 months, by September. But in August, the Commission brought forward legislation to extend the 9-month transition arrangements for a further 9 months. Why was that necessary, given we were so confident that we would pass the test in good time?
So it's a question that probably should be put to the Home Secretary and those involved more directly with this. I know that this process has taken a little bit longer than we hoped, and I think for some practical reasons rather than anything else. It's not the first deadline that has been pushed back, as we were discussing, to provide for more scope to do things right. And I think it is not a sort of big issue between us. It's simply to provide more space to achieve that. And of course, it's not stopping prune DNA and fingerprint exchanges going on meanwhile.
So that suggests that you're confident that, I mean, we only have 9 more months of, because there's only one postponement of the existing arrangements that's allowed. So you're confident that within the next 9 months we will sort these things out. Because I guess what the obvious question is, what if we don't? There isn't any provision for a further extension.
No, so I don't see any reason why we won't do this. I don't think there is any kind of underlying difficulty here, and I'm sure we'll be able to put it in place.
Thank you. And just one further question, and I hope this doesn't sound too whingy on behalf of the committee or the House, but we were appointed by the House to consider matters relating to the UK's relationship with the EU, obviously, and that includes, crucially, the implementation of any agreements between the UK and EU, between the UK and the EU, and EU documents deposited in the House by a minister. Yet we and Parliament knew nothing about this significant matter that I've just raised. What does this reflect, as some people are suggesting, a view on the part of the government that it's just not interested in parliamentary scrutiny of its relationship with the EU? Because so far, to be honest, we've seen precious little evidence that there is an interest in doing that.
I can't speak for everybody. All I can say is that I have tried to be open with this committee, and I think we're still in the middle of a discussion about the scrutiny arrangements and the amount of documentation that could be exchanged. And I'm sure we'll be able to bring that to conclusion very soon. But it's certainly not my intention to evade scrutiny in any way, and I think my frequent appearances between this and in front of this and other committees show that. I believe, and I'm sure colleagues would believe, that it's important that significant developments are, appropriately drawn to the attention of the appropriate committee. I think that's just reasonable, and if it's not happening, that's a pity. Obviously, significant is a term to which one might bring judgment. It's not necessarily objective, but I think we know what it is when we see it, and I think it's reasonable that committees be kept in the picture. Certainly that's what I've tried to do.
Okay, thank you very much.
We'll certainly come back to that. Yes, you're quite right, Lord Frost. We're still in these discussions. I think the discussions are moving out of a phase where it's been handled by officials, and it will be, I'm afraid, a deputation of committee chairs that will come to see you quite shortly on that. But in the meantime, Lord Purvis.
Thank you, Lord Chair. Good afternoon, Lord Frost. In your Lisbon speech, when you were referring to the issues with the Northern Ireland Protocol, you said it was when, I quote, the UK's negotiating hands were tied. Are there any constraining factors, or is there any hands being tied for the UK negotiating over Gibraltar?
So, I mean, there are obviously Northern Ireland and Gibraltar are very different questions. I think that's the first thing I would say, although there are some analogies to be drawn between some of the things we're doing there. I think they are very different. We are in a negotiation on Gibraltar, the shape of which, I guess, is constrained by the very good political agreement that we reached at the end of last year, and we would just like to see that given legal form as expeditiously as we can, and discussions have begun on that, and they're quite constructive, and I hope we'll be able to get there before too long.
I'm assuming that's a no, so there's no hands being tied or there's any constraints on the UK. Because in the 29th of March, the press release that was issued from the Foreign Secretary and the Chief Minister, in paragraph 11, we are prepared to make level playing field commitments. So presumably this is aligning with European laws for Gibraltar, proportionate to the market access for that territory, without consent for the people of Gibraltar. So that is the case, yes?
So I think, that statement you're referring to is obviously co-signed by, I think it's the one I have in mind. It was signed by the Chief Minister. So I think he represents the people of Gibraltar. I think we do recognise that, as indeed in the political agreement, it's necessary to put in place a minimum of provisions to enable the border to flow freely between Gibraltar and Spain, and that's required one or two unusual things. But the fact is that Gibraltar doesn't produce many goods, and so some of the questions of alignment and customs that have come up are not, are minimal. I think the EU's aspiration is to do a lot more. At least that's what we judge from their mandate. And
the UK position is it still that it favours a foreign entity, the EU, through its Frontex agency, to use its procedures and processes for checking on British territory?
Or checking entrance into the Schengen zone,
which Gibraltar would be.
Gibraltar Airport.
Yes.
So
it is the case.
So that's in the political agreement.
Yeah. So having the best border in the world includes a foreign entity policing part of it. Is that correct?
In the context of Gibraltar, yes.
So the consent how will that operate within Gibraltar when it comes to this treaty? Will it be that the First Minister of Gibraltar has to say to us as a committee that Gibraltarians are happy with this treaty? Or how will consent be realised? How will it be demonstrated? Because Gibraltarians have no representation in this Parliament. So how will, you indicated, reconcilable with democracy, how will that apply for Gibraltar?
So I think this is an issue that is being discussed in the negotiations, which have been led by the Foreign Office, I should say, not by me, though I accept that there's some read across between the two arrangements. I think you are trying to sort of generalise too much from the extremely specific circumstances of Gibraltar into wider areas. Our approach in this is to work with the elected political authorities in Gibraltar, i.e. the First Minister, and to put in place arrangements which they are comfortable with. And that's what we've tried to do last year. That's what that statement says, and that's what we're trying to do going forward. And that I think is the only reasonable approach that one can take.
I was just asking for your view, Minister, because your Lisbon speech goes back to Burke. It goes a lot in principle.
It does.
And not in this very, you didn't say, you preface it by saying this is only applying to very specific circumstances and areas. This was principle. So what is the principle for Gibraltarians approving? You indicated that it's the First Minister at the time of the agreement, the treaty. But we are a sovereign parliament here that decides, so there's no mechanism for us. We have to take your word for it that democratic reconcile has been reached for us passing laws which will then apply specifically to Gibraltar to align Gibraltar to the certain aspects of the single market for goods, not for customs, but single market. That's correct.
I think you're trying to stretch the elastic, if I may say so, Lord Purvis, of the relationship between this government, this Parliament, the authorities in Gibraltar, the very special arrangements around Gibraltar, and the issues that produces. I think you're trying to stretch that a bit further than it will really bear, and I don't think you can draw the general conclusions that you're trying to draw from those very specific.
So simply asking, Minister, if this treaty is implemented with you want, which is that part of a British overseas territory will be aligned to European Union laws, that how will we then legislate for Gibraltar when it comes to those laws?
So I repeat what I have said, that Gibraltar is an entity which has a relationship with this government, which is a familiar arrangement, which is an overseas territory. Gibraltar has its own elected authority, it has its own constitution, and is very closely involved with us in preparing these negotiating positions and the talks. And I think that is honestly all I can say at this point. And I would say that, as I've said before, this is a negotiation that the Foreign Office are leading, and I think the details of this. The details of the negotiating position should also be addressed to them as well as to me.
Thank you very much. I think we'll have to carry that on in correspondence. In the meantime, our leading fast bowler, Lord Fox.
Lord Frost, you negotiated this treaty and you commended it to us at the time. Do you not find it a little embarrassing that you're renegotiating it across such a wide area so soon after it was signed by the government and approved by this Parliament?
Not really, because circumstances have changed, and
what circumstances have changed so quickly?
Well, the fact that there is very clearly no longer cross-community, cross-party consent in Northern Ireland for the protocol. That is very clear, because all the unionist parties have put out statements saying that they would like the protocol to be rejected and replaced, and that's very clear.
You didn't anticipate that might happen?
So we put in place a protocol that included quite a lot to be worked out afterwards, which we tried to do. Michael Gove did last year, which included a lot of novel areas, which had as its overriding purpose the support for the Belfast Good Friday Agreement. And we knew that much of this was novel. That's why there's an explicit provision in the protocol under Article 13.8 that it can be superseded in whole and in part, why we have to have a safeguards, and it's why there is a consent mechanism. So, it's unfortunate that the cross-community consent no longer exists, and we have to come back to these questions a bit sooner than we thought. But I don't think we can fairly be said that this was not the circumstances that we anticipated.
Do you not think this is going to create huge problems for us when we negotiate treaties in the future with other countries?
Well, I hope we'll never negotiate one in quite the same circumstances that we negotiated it in October 2019, when this Parliament restricted one of the major options in those negotiations, i.e. that we could leave without a deal, and left us with the ability only to take what was put on the table and do the best we could. I do hope we never negotiate anything in those circumstances again, because it's self-evidently not ideal.
Well, we'll have to disagree on that matter.
Yes. Could I just follow up on that? Surely, perhaps you'll correct me if I'm wrong, at the time you struck the deal to which you put your name, and so did the Prime Minister, it was opposed by the DUP. It wasn't accepted. So it was always opposed by the DUP. Could you tell us a little bit about your contacts with the other parties in Northern Ireland, Alliance, ESDLP, Sinn Féin? There isn't a huge amount about that in the reply you sent to our committee's report on Northern Ireland. That's a polite Foreign Office way of saying there's nothing about it at all.
Nevertheless, I do have contacts with such politicians, and I do meet the representatives of the Alliance and SDLP and indeed Sinn Féin from time to time, and indeed one of the reasons I need to I can't give much more than an hour to this hearing is because I've got to go and do one of those contacts. So we do our very best to stay in touch with the whole range of political opinion. Obviously, Brandon Lewis, as Secretary of State, does a lot more of that than I do. Of course, it's our job to remain in touch with the whole range of public opinion in Northern Ireland, and there is a range of views on the protocol. It's unfortunate those views are quite polarised and undercut the support it needs to operate.
Thank you very much. Indeed. We've got two, and then we'll have to finish. So first Lord Little and then Lord Faulkner. Lord Little.
On this Northern Ireland point, do you support the efforts of Vice President Šefčovič to establish direct relationships with the parties in Northern Ireland in order to get a better understanding of what changes may be required?
So it's a free country, just about, and we wouldn't want to put obstacles in any way to anybody coming to the UK and finding out more about it. And I think the more the Commission understands about the circumstances in Northern Ireland and the pressures upon the actors, the better that will be. I mean, I have said before that I think visitors to a country should respect the fact they're in another country, and especially if they're not part of the government of that country. But I think it's very useful to have him there and seeing more and establishing contacts, just as I don't feel inhibited going to EU countries and talking to anybody I wish there.
Lord Faulkner.
Staying with Northern Ireland, Lord Frost, looking back and bearing in mind what happened to Theresa May's proposed deal, which contained a backstop, do you think that the reaction to that would actually have been any worse on the part of the unionist community than it's been to your protocol?
It's speculative, obviously. I think and their opposition to it's obviously a matter of record. I think the problem with the backstop was not only the problem in Northern Ireland, but the fact that it kept the whole of the UK in the customs union and effectively required alignment to the single market for goods and bits of it across the whole of the UK. So that was the difficulty and the reason why it was never approved by this Parliament. I think it's sort of speculative whether we'd have got to the same point. The pressures on the government if the backstop had been enforced would have been so different. I mean, I can't quite imagine how they would work out without even more severe tensions than the ones that we've got. The decision that we took in October 2019 was deliver Brexit for the whole country and give openness about the future for the country, and if we didn't have that, I think things would be extremely difficult. Is all I would say.
Well, thank you very much, Lord Frost, and thank you both for being with us today. Sorry, Susanna, Simon, that we didn't get to hear from you, but that, I'm afraid, is a reflection of the reduced time that we had today, and the questions, obviously, that you would have been very helpful on simply weren't able to be asked. But we look forward very much to seeing you again here shortly to continue the conversation. In the meantime, thank you again, and I declare the meeting over.
Thank you. Thank you, Chair.
The proceeding has ended.